The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Welcome to this March 7th sitting of the Massachusetts Appeals Court live on Zoom. We are going to be hearing the case of Haas and others versus Michi and others, 22P0435. And before Mr. Haas begins his argument, I'd like to put on the record that he has informed us that the other co-plaintiffs did not receive notice of this oral argument, but that they do not wish to have a postponement, and he will go forward with the argument. Is that accurate, Mr. Haas?
Yes, yes, it is.
And I have promised him that we will look into how that happened. All right, wait just a second to see the timer, and then you may begin. There we go.
Thank you. Thank you for this opportunity to present our side to this honorable court. We are here due to the appellees implementing a standard operating procedure, also known as an SOP, in 2019, which denied all prisoners the ability to send money from their personal account to any individual, regardless of the relationship or purpose, unless the request was to a non-person entity and accompanied by a bill or invoice. This SOP included both earned and unearned funds, and the enabling statute was Chapter 127, Section 48A. I would like to return to both of those later in the argument. We filed a verified complaint in Worcester Superior Court, claiming that our rights were violated under the First and 14th Amendments to the U.S. Constitution and Article 30 of the Mass Declaration of Rights. The appellees filed a motion to dismiss for failure to state a claim, and I'd like to note that they have yet to answer the verified complaint. We contend that Justice Peter Hodge, after an oral hearing on May 18th, 2021, erred in allowing appellee's motion to dismiss for failure to state a claim, and then thus dismissing the appellant's verified complaint. We assert the following grounds to support our contention. One, that the funds in our personal accounts constitute a protected property interest under the 14th Amendment. The appellees have never contested this claim, and Justice Hodge made no adverse finding in his memorandum or order regarding this. The appellants contend that the 14th Amendment protects them against arbitrary and capricious actions, of which we believe denying us the opportunity to send funds to any individual for any reason at any time is clearly arbitrary. And we also believe that we have raised sufficient facts with reasonable inferences therefrom, enough to rise above the level of speculation and to overcome a motion to dismiss. During the hearing with Justice Hodge, I had stated on the record that we were there, at least we believe we were there for a motion to dismiss and not for summary judgment. Because if we had been, then we would have taken a different tack. We believe the undisputed facts that we have submitted are that all of us followed the procedure for submitting the proper form with requested information to the proper official. All of us were denied. 3, because the payment was to individuals not without a bill or invoice. All of us are lifers and exempt from the enabling statute, which I will get into a little later. And none of us have ever tested positive for drugs or engaged in or accused of engaging in any illicit activities, including, but specifically, the ones that the appellees point to: drug smuggling, money laundering, or
Mr. Haas,
yes.
Correct me if I'm wrong, but my understanding is what you're asking for us to do is say the SOP is invalid.
Yes,
not to say any particular SOP decision was wrong, that the whole thing should be struck.
yes.
And let me follow up on that. You've raised a number of arguments in your brief, obviously. But the one I'm particularly interested in is you cite the cases concerning whether the standard operating procedure is only something that affects the internal management of the agency or affects members of the public. You cite the Trumbull case and the Carey case, Carey versus Commissioner of Correction, both of which are about whether a set of procedures had to be promulgated or issued as a formal regulation under Chapter 30A, the State Administrative Procedure Act. My question is, are you contending that one of the grounds on which the SOP is invalid is that it not only conflicts with the existing regulation, but that it had to be issued as a regulation itself in order to be valid?
We have never made the contention that the SOP needs to go through a public hearing process, and therefore, as a regulation under 30A. Our contention is that on its face, it is invalid. We do not believe that holding a public hearing under 30A is going to do anything to correct the issues that we're bringing up, because so no, that has never been our contention.
All right, well, then I was puzzled why you talked about whether this was the SOP was merely for the purpose of internal management of the agency, because if it were, then it wouldn't have to be a regulation. But if it's not, then it very well might have to be a regulation. And that's what the Trumbull and the Carey cases that you were citing were about. So is there something about those cases that's relevant here that I'm missing?
No, I would not say so. I would say that what we're arguing is we're dealing with the public and how this affects the public, which is one of the arguments under those cases. And our argument is that it affects the public, and an SOP is not supposed to be anything other than an internal explanation to employees as to how they are to conduct their work. It is not supposed to extend beyond that, but this one extends to public and extends to us as inmates, prisoners, who are not employees.
So do you contend that the SOP conflicts with the regulation? Is that correct?
The SOP conflicts with the, yes.
And what I'm understanding your argument to be, and please correct me if I'm wrong, is that the regulation essentially says the inmate has to fill out a slip that shows the date, the amount, the purpose, and then the inmate signature, and there's got to be a staff verification signature. And then the department accounting clerk shall review that slip to see if the signatures are there, ensure there are sufficient funds, and if so, then the clerk is obligated to disperse the funds from the account.
Yes.
Whereas the SOP injects an extra layer into that. It not only, you don't have to just fill in the blank saying what the purpose is, you need to attach some documentation such as a bill or a pledge or some other form that indicates exactly how the proposed disbursement is going to be used.
That is correct. But what the SOP bars is any disbursement to any individual. In the case that you brought up, I would have to give the disbursement to a non-person entity with a bill or invoice. But that doesn't apply to significant, no, it doesn't apply to what I was trying to do, or appellant Cowan or appellant Alford, because if you look at what the appellees suggested, and we're sort of getting into Turner Factor 2 here, what they suggest is that we could spend our money by buying a gift.
Just
Or,
isn't practical, it's burdensome.
yeah, or paying an invoice.
Yeah.
Well, if we could just use the example of Cowan, his he wanted to contribute $25 to his mother to help pay for her to come from Missouri to Massachusetts. Their alternative was for the transportation company to deduct $25 from the bill, then bill Norfolk for $25. And that is totally impractical. You know, it doesn't make any sense.
And the part of the SOP that you say prohibits transferring to any individual is the part that says an inmate's request for disbursement for a monetary gift shall be deemed invalid?
Yes.
Is there
Yeah.
any other part that says you can't transfer to an individual?
I'd be very honest with you, sir, I'd have to go back through because I'm not with it page by page, but the SOP is based on the assumption, and it is in the SOP, that all of the, let me just get the exact, you know, of course, I'm not going to find it right away, that funds are used for illicit purposes, and therefore they're going to cease any personal funds because they are used for illicit purposes. I'm sorry, it's right in front of me. It says in the SOP 2A subsection 2, it says are frequently used for illegitimate
Right.
purposes.
Okay.
Okay, so our argument is there has to be some nexus between what we were trying to do and illicit purposes in order for us to be denied. In fact, in the case that Judge Hodge cited on Massachusetts Prisoners Association Political Action Committee, the SJC put in, and it's an interesting wording because this is not what the appellees do. And they said amongst the things that there's a request for transfer from personal account, the official must consider the identity requesting, the identity of the proposed recipient of the transfer, and whether the transfer relates to any illicit activity. Now, that is not what's happening. They are simply assuming that any disbursement to an individual is by default illicit. And that's the essence of our argument, because what they're basically saying is everyone that we would send, are they potential drug dealers? Whatever. It is how do I say it? That is the essence.
Paints with too broad a brush, I think, is what you're.
Yes, thank you very much. Thank you. I see what, okay. Thank you. We talked about, okay, because I'm running out of time. I would like to talk about the Turner versus Safely case, because Justice Hodge and the appellees depend upon that case. And we believe, at least for the factor 2 and factor 4, that it's misplaced. I've already discussed briefly factor 2, which is an alternative means. The other one that I think is more relevant is factor 4. Turner factor 4 asks, does an alternative exist which would fully accommodate the inmate's rights at de minimis cost to valid penological interest? I need to be very clear. We have never, ever contended that any money should be sent out for illicit purposes. It's in my best interest that it not be done as well as others. But Justice Hodge and the appellees view this not as de minimis cost to, the appellees, but de minimis cost to the appellants. In other words, if it's a de minimis cost to us, then it can stand gifts and so forth, the de minimis cost. But that's not what this factor says. And my point is that there is, and has been for the 40 years that I've been in Norfolk, a procedure that if any charge request is considered by reason, any suspicious, it is investigated. That's what the Inter-Perimeter Security Force, that's what happened to me on an affidavit, without my going through the details, that I've included. And they investigate this. And if there's any, and if it's found to be illicit, it's denied. And we're not arguing that.
But Turner factor 4 focuses on the burden on the prison officials as well, doesn't it? And
Yes, yes,
for, you know, in a correctional facility of several hundred inmates, if a certain proportion that were sending out payments to individuals every so often, investigating each one of those to determine whether the purposes may be illicit is a pretty substantial undertaking on the part of prison officials, isn't it?
well, it depends on, I don't know the criteria that they use. Obviously, it's a security measure. One of the criteria, I believe, is the amount of the disbursement. If I were trying to send $1,000 to someone, that raises a red flag.
Right, but
Sure.
since you don't have much time, I'm going to interrupt. Attorney Handler answered that question at the Superior Court oral argument by saying, yes, but if you send lots of small amounts, that eventually adds up and can certainly be equally used to accomplish illicit purposes. Not suggesting that you are doing that, but it could be done. And the department has a legitimate concern about that.
Yes, but all due respect, $50, $40, $25, $10, and that's what we're talking about here, is not funding drug smuggling or money laundering or anything other than what it's on its face is what we try. That is that's one distinguishing factor, that they know that monies for less than whatever their criteria is not anything to be concerned with. So that they have some criteria, and they also know that who it is that they believe is involved in illicit activities. And that's not all of us prisoners. So I think my time is up. So I thank you for that.
Thank you. Are there any other questions from the panel? Okay. Thank you very much. Attorney Handler.
Yes, good afternoon, Your Honors. Thank you very much. As I indicated, do represent the Department of Correction defendants in this matter. And the department maintains that this standard operating procedure is in fact consistent with the regulation that exists. And the problem with this case is that it was brought as an action for declaratory relief, but none of the plaintiffs in this case even allege that they complied with the standing operating procedure. Therefore, there is no way to tell whether or not their requests would ultimately have been allowed if they had properly grieved them and followed through with that. None of the individual facts are in the record. That is why the fact that the other plaintiffs are not here is not really relevant to the argument, because the department's position is that the standard operating procedure is a strengthening of the underlying regulation, in effect, which asks in 405.12, the regulation requires the individuals.
Before we get there, do you know why the others weren't notified?
I am not in charge of the HABEs that come from the court, Your Honor. I don't have any personal knowledge of that.
But you'll be of assistance if we need it.
I absolutely will be of assistance. Okay. Nobody contacted me and said, is there a way to have them present? The court, when I do have multiple plaintiffs, the court arranges it usually. In fact, as you see from the Superior Court transcript, they all appeared and they were all permitted to argue.
We'll track it down, but back to your argument.
Okay. Again, I don't think it makes a difference, Your Honor, because the individual facts are not before the court. I know that, and for example, I know that Mr. Haas represented that one of the plaintiffs, I believe it was Mr. Keon, wanted to have his mother come visit from Missouri. If in fact I have checked the records, his mother has since come to visit from Missouri. I don't know how he was able to assist her with regard to the financial requests. The plaintiff's financial records, and this would have been if they had challenged it individually, show that they have since been able to make donations. Donations up to.
You were about to tell us why 405.12 requires this.
405.12 does not necessarily require it, Your Honor. It allows for it. It requires that the plaintiffs or an inmate state the purpose for his or their request for disbursement of funds. 405.13.13 requires that the documentation, supporting documentation for the purpose be present when the superintendent or treasurer sign off on the check. The essential problem with this is the department would become a laundering institution if we did not verify the legitimacy of requests for disbursement of funds. It's both, there was, and I did mention this at the Superior Court argument, some financial institutions will not take checks from inmates, like Fidelity will not process stock requests from inmates. The department is more than willing to undertake the investigation that Justice Sachs indicated may be cumbersome. We understand that that does come with the SOP, and we would be required.
I'm concerned not about the wisdom of the SOP, but whether it complies with the regulations. 12 seems to say that the treasurer shall disperse the funds in accordance with the request. There's nothing about verifying the purpose or that a purpose of giving a gift is banned. So it seems to say that this SOP seems to be inconsistent with 12. So I'd like an argument as to why it's not.
Yes, Your Honor. 12 does say that the plaintiffs must give a purpose. The SOP is a strengthening of that request in that we need to be able to determine whether or not that purpose, if they just write, I want to pay a drug debt, and they've stated that purpose, does that mean the department should have to pay that? I mean, that is why the SOP is important, because the department needs to determine the legitimacy of the purpose, because under 48.
The SOP may well fill a gap that is important for prison administration. The question I have is whether it conflicts with the existing regulation, whether it prohibits something that the existing regulation mandates, and more particularly, whether the SOP didn't have to be issued as a regulation. It certainly is of general application and future effect, and it certainly doesn't just obligate or appears not to obligate merely correctional officials, but it places obligations on inmates, who are the portion of the public that the agency, one portion of the public that the agency serves.
Your Honor, the department's position with regard to the 405 is that the department is a fiduciary and acts as a trustee for all inmate funds, and therefore has an obligation under under 48A, excuse me.
Well, maybe that's a gap then. Maybe that's something that should have been in the original regulation and should be put in an amended regulation. And I think one of at least the theory of notice and comment rulemaking is that you can take into account the many different perspectives on what purpose the regs need to serve and what kinds of problems individual inmates are going to come up against with sending money to someone for a bus ticket or a birthday gift or whatever it might be. And there are ways to take those things into account in the text of the regulation. But this was just issued without any advance notice that I saw in the record, and doesn't take any of those things into account. Wouldn't this, why isn't this subject to 30A? That's
I would suggest because this really does have to do with the internal management of the department, and the department under chapter 124, 1U and 1Q has the authority to formulate rules with regard to inmate accounts and the processing of monies and withdrawals for request, and chapter 127, 48A requires the department to act as a fiduciary. I would also direct Your Honor.
The authority to issue a regulation like what says in the SOP, but that doesn't answer the question whether this SOP itself had to be issued as a regulation.
I would suggest that it does only deal with the internal management of funds. It does not affect the public. It is not it is not a huge infringement upon the public.
Well, aren't
And
you-
as Mr. Haas has indicated, he said, you have to, all the department is doing is the department is prepared to undertake the investigation that would be required. But the problem is that the plaintiffs in this case did not comply with the regulation, the SOP, excuse me. They did not provide.
SOP says that all inmate requests for gifts will be deemed invalid. How is that just internal? Why doesn't that affect both the inmate and the recipient of the gift?
I would suggest that that actually is a presumption, Your Honor. If you look at section 2.5 of the SOP, there are individual requests for one-time disbursements that can be made. The department does process gifts on people's birthdays. Would suggest what happens is you may have inmates who are all giving $50 to someone on their birthday 6 times a year, and there are 5 different inmates giving it on different dates. That's the type of investigation that the department needs to undertake. And without the plaintiffs complying with the request for documentation to support the legitimacy of the purpose, and again, in 405(7), there is a need for legitimacy and a compelling need for disbursement of those funds. The department was unable to even investigate. In this case, the plaintiffs are saying that.
I don't want to get too far off on this, but the allegations of the complaint were that several grievances were filed. Some of them were denied. A couple, I think, were appealed, and maybe no response was received. So I haven't chased each one of those down. It seems to me the plaintiffs are really challenging the overall validity of the SOP, not the individual applications to them.
They are, Your Honor, but the problem is that none of not all of the plaintiffs in this case, I would say none of them actually provided the requested documentation. So they did not give the SOP an opportunity
Part of their allegation is that they can't provide the documentation because the nature of the documentation being imposed is unrealistic. So, and this is all, this is all at a very preliminary stage. But I think it would be really helpful if you could return to Justice Sachs' question about whether or not this impacts the public, because it does impact family members. We have direct allegations that there have been efforts to make requests. There's an allegation that there's been a request to make a political contribution, which would implicate the First Amendment. There's been an allegation that somebody wanted to make travel arrangements for their mother, and that it was unrealistic to expect the bus company to take a partial payment from the prison. So how do we say that this does not impact the public?
Your Honor, I would I would say that the evidence, well, it's not before this court, but as I indicated, the individual who wanted
the court, we don't go outside the record.
But the Diorio opinion, which is in the addendum, indicates that plaintiffs could pay because money is a fungible amount, they could pay a rent bill for someone.
Take judicial notice of that.
Yeah, it's in the record, Your Honor, the Diorio opinion.
It may be, but we can't take judicial notice that the landlords of these individual prisoners, family members, are going to take this kind of payment. It's just not anything we can do, I don't think.
I'm not sure in terms of whether judicial notice needs to be taken, whether a landlord will accept a check. The department.
That's really, I shouldn't have gone down that road because that's not the issue. The issue is not the individual checks. My question to you is, how as a matter of law do you say that this SOP does not impact the public when we have direct allegations in the complaint demonstrating an impact on members of the public?
Again, what I would say is there is no allegation from any of the plaintiffs that they tried and were unable to provide the documentation requested. They didn't even allege it. And if you read the transcript at the Superior Court, they just challenged it by not complying. And that is the problem.
I want to make sure I understand what provision of the SOP you say permits gifts, in essence, even though there's apparently a blanket prohibition early on. I'm looking at part Roman 2B5, which begins requests for disbursements for special matters, such as paying child support obligations, returning bail funds, one-time requests for back to school supplies, et cetera, require additional verification to ensure the legitimacy. Is that what you are saying is the safety valve that might allow gifts in particular circumstances, or is there something?
That is the safety valve. I don't know that I would term it as a safety valve. That is one of the provisions that would allow gifts for one-time matters. I would suggest, Your Honor, also looking at 2A2, where it specifically says that gifts shall be deemed invalid, such as it says later on in that paragraph, if the disbursement for a purchase of the gift is approved, payment will be made directly to the outside business. So in effect there,
that's to purchase a gift. That's not to make a gift. I don't understand how that gets around what the plaintiffs are saying we want to do, which is to give a monetary gift or other payment to an individual to pay for a bus ticket or to pay for that individual's investments in stocks for their future or whatever it might be.
I would say that the onus would be on the department to investigate whether or not it was a legitimate request for a gift, and the department could process all of the plaintiff's requests, and that really is the essence of the case here. Is had the plaintiffs complied.
Now I'm really confused. You telling me that you under this SOP you can give a monetary gift to an individual as long as you have documentation.
I can't speak to exactly what the purpose is, but if it is, there's a list of factors.
This is your SOP. How does it work? It seems to say you can't give monetary gifts. They're deemed invalid. You're telling me you can give monetary gifts if something. So
the department does send monetary gifts to people on their. I'm out of time, Your Honor. I can't answer that question.
No, you can answer my question.
Okay. The department does allow monetary gifts, and there are factors outlined in the SOP, such as, is there a history of such gifts? Is there a familial relationship? Is there, and that is in the SOP, when the factors to look at when deciding whether or not a request is legitimate. The department has to conduct an investigation, and the department is willing to do so in connection with each and every request, but the plaintiffs in this case did not permit the department to do so because they did not comply with the SOP.
So to return to my earlier question, the difficulty that I have with that argument, and I may have inartfully phrased my previous question, is that this came up on a 12B6, and the argument that you seem to be making appears to be extremely fact-based. And I'm really just not sure how we deal with that. We would be in a different position if this came up on a motion for summary judgment, but it's come up on a 12B6.
The problem,
grievances were filed and denied.
They were not. Mr. Haas, for example, didn't even file a grievance, and that is the problem. He would have.
That's not a complaint. We're only on a 12B6, and you seem to be relying on things that we don't have. Because
I'm relying, Your Honor, on the absence of things in the complaint, and on the fact that the argument set forth in my brief suggests that any of these requests could have been allowed, and there is nothing in the SOP that says they were not to be allowed.
Because it doesn't actually ban monetary gifts.
It does not actually ban all monetary gifts. There needs to be an investigation, and that could not occur in this case because of how it was brought. This is not the case on which to decide, because each of the plaintiffs would have to show that they properly grieved and they didn't file certiorari claims.
It's tough for us and for the plaintiffs when we have an SOP that they say is invalid and you say doesn't say what it says, or at least it's not going to be executed the way it says what it says. I mean, it puts us all in a difficult position.
I understand, Your Honor. I would suggest that this is not the case to make a determination on the validity of the SOP, specifically because of the manner in which it was brought, and it was not, the the plaintiffs did not file challenges of their grievances in court and therefore show that they had been wronged.
All right, are there any further questions? Thank you to you both for your cogent arguments. That